Lots to talk about here. In the midst of this whole Obamacare fiasco and the fix that the president introduced today and all that, something that's gone unreported, and that's not what we're here to talk about, but the fact is it's basically gone unreported for the most part, is that an appeals court, a federal appeals court, last Friday blocked a key provision of the Obama administration's health care law, the one that it requires employers to provide birth control coverage and employee insurance, and they said that it imposed a substantial burden on religious rights of two Midwestern companies. This was the 7th U.S. Circuit Court of Appeals in Chicago, and Kendall, as you know, it's the first time a federal appeals court has issued a ruling preventing the enforcement of this provision. So this is hugely significant, or am I overstating it?
No, you're not overstating it. The Seventh Circuit, sort of in the middle of the country in Chicago, is considered a centrist court. So it's not viewed as overly liberal, not overly conservative. It's a very respected court. And while there are other federal appeals courts weighing in on both sides of this issue, and this is the issue that perhaps from a legal standpoint, ever since the Supreme Court made the major decision upholding the law, this is the one legally, the questions of a contraception mandate that has gotten a huge amount of attention. Now, for the first time, a respected sort of middle-of-the-road federal appeals court has actually blocked the enforcement of law. So, there are some very significant elements of that, not the least of which is the court itself is probably thought of as a moderate court. But for an appeals court to actually issue its order blocking a federal law, that's a real big deal.
Yeah, and the argument by the Justice Department had been that the for-profit companies have no religious rights. We've heard about the cases where church-related businesses or operations and religious-related facilities, hospitals, whatnot, they've launched their own objections. But this was a business, and so the argument from the Justice Department that they're for-profit, so they have no religious rights, this federal appeals court decided against and issued the injunction, nonetheless.
And, of course, the appeals court, I'm sure, is considering, as all the courts do in this area, the implications of the Citizens United case, which, as we know, in the context of campaign contributions, said that, companies are within the scope of the First Amendment. Well, if they're within the scope of the First Amendment for purposes of political expression and political support, what about that part of the First Amendment that protects religious freedom?
Yeah, no, this is huge. And again, this story that I had forwarded to you talks about the fact that very, very, very few establishment media outlets have mentioned this at all. And it's just fascinating how they pick and choose what doesn't meet their agenda. Let's move on. Another issue, and this is something where I've had the attorneys on for these folks. The two Christian photographers ordered to shoot a gay wedding are now appealing their case to the U.S. Supreme Court. Attorneys for the couple in New Mexico were told by the courts that they may not refuse to shoot a homosexual wedding in the state. Have appealed to the Supreme Court, and the two of them, the woman and her husband, in Albuquerque, this happened back in 2006, and they refused, and because of the laws in New Mexico, they were told they had to do it.
And we talk about how what courts often have to do is balance the competing interests. You'll have on each side of a question perhaps a very, very powerful, even momentous value that our society respects. What value is more cherished in our entire constitutional structure than religious freedom? As you know, when this country was founded, when the First Amendment was enacted, there was probably no part of that First Amendment that was more important to our founders than religious expression. Obviously, since 1954, Brown versus Board of Education, the policies condemning discrimination have gained ever increasing force. So now these two policies collide in what is a very well-defined battle, because when you talk about these photographers, their claim of religion seems to be legitimate in the sense that these are sincere values, and they're not looking for an excuse to avoid law. They're standing up for what they believe. On the other hand, we know that the states have laws that can prohibit a broad range of discriminatory conduct, including who you do business with. So it's a remarkable and profound collision. One of the big questions is, you look at this, Steve, and it seems like it is the perfect case to tee up and give the Supreme Court the chance to look at these competing considerations and give some decision-making that hasn't happened before. But will they want this one? Will this one be seen as just too controversial? And could they just say, leave it to New Mexico? That's the decision of their state Supreme Court. This doesn't necessarily apply in the rest of the country. So,
now, what do you think? That was going to be my next question, too. So what do you think? Because it is so well defined, as you put it, and because one of the judges in the in upholding the lower court's decision actually wrote that the couple may freely live out their faith privately, but when it comes to running a public business, they'll have to, quote, pay the price and check their Christian convictions at the door. I mean, that's pretty strong language. And, so this seems like a perfect case for the Supreme Court to pick up on and either say, yeah, that's true, or no, it's not.
Well, the issues couldn't be better presented for them to make a decision. But here's the question. The Supreme Court seems to want to strengthen religious values within our constitutional system, give more protection. I'm referring to a majority of the Supreme Court, and I think we'll see that with the recent case about a prayer by a city council at the beginning of the city council meeting. I think religion's going to win that. Do they want to make this a test case for religious freedom, given the inevitable controversy that the case would bring in terms of those who consider themselves opponents of discrimination in any form? Is important and powerful as these questions are in this case, it's possible that the Supreme Court could say, look, we want to make sure religious freedom is advanced during this Supreme Court's tenure, but this case maybe brings an awful lot of controversy with it.
Yeah, we're talking to Kendall Coffey on our Spinning the Law segment here on the Steve Malzberg Show. Of course, Kendall, the author of a book by the very same name, not the Steve Malzberg Show, but Spinning the Law, which I recommend highly. All right, let's move back to the kind of a sidebar in the George Zimmerman murder trial. Actually, I think this was even before the trial, maybe even before he was arrested. Spike Lee, famed director, famed Knicks fan, he tweeted out the address of an elderly couple, believing that it was Zimmerman's address, and they claimed that Spike Lee put their lives in grave danger, and they filed a lawsuit saying they received numerous death threats and hate mail, feared for their lives, as their address was retweeted countless times. And the couple, the McLeans, say Lee's tweet of their address encouraged, quote, a dangerous mob mentality. And now I guess they're looking for some restoration.
Well, people who value our law, as you and I do, like to say that for every wrong, there must be a remedy. And this certainly seems like a wrong, the way it's at least alleged by the plaintiffs. And one might think there should be some kind of remedy if indeed they suffered what we can well understand might have been a firestorm of threats and abuse. But a few years back, the Supreme Court of Florida, Steve, decided that the kind of claim for what they call violation of privacy, putting somebody or casting somebody in a false light through publicity that's damaging, that by itself is no longer, in the state of Florida, a valid basis to bring a claim for damages. What these individuals would have to claim is either something called intentional infliction of emotional distress, and it's hard to think that they can show enough intentionality. Maybe they can on the part of Spike Lee, or if they can present it as a claim of defamation, libel, slander, those are concepts you and your listeners are very familiar with, maybe they can get somewhere. But despite what makes us all sympathetic, if indeed what happened here is as they describe it, I'm not sure they're going to get to first base, or certainly not to second base in terms of a lawsuit, given the decision the Supreme Court of Florida made, which actually gives less protection for individuals whose privacy rights are invaded and are wrongly subjected to negative publicity.
Very interesting. Very interesting. All right. That doesn't seem right. Doesn't seem fair for these people who had their address tweeted out falsely or without justification. But anyway, the law is the law. We'll see how that plays out. All right. Now, this case, finally, the special prosecutor, there was this an assistant state attorney general appointed special prosecutor and determined in the Ryan Ferguson case that they will not retry him. This guy is free after spending 10 years in prison.
Yeah, I mean mistakes happen. That's never satisfactory to anybody who believes in our system of justice. Against the defendant, even though they apparently later recanted, our system will allow that kind of testimony to be a basis for conviction.
Well, actually, what I should say, I believe, unless I'm missing something, I believe that I'm confusing myself. That last Tuesday he was in a robbery and murder conviction on Tuesday, and now they've appointed a special prosecutor to decide if he'll be retried. Is what I should say. Right,
and the special prosecutor is apparently announcing that they are not going to retry it. And when you talk about cases where there's a sense that the system may have made a mistake, what is so often turns to be the key is DNA. Witnesses change their story, but a lot of times, Steve, if somebody's prosecuted and convicted and then later on witnesses change their story, that's not necessarily considered to be a grounds to throw out the conviction. There are a number of cases where some witnesses have said afterwards, I didn't really mean what I said under oath in front of the jury, and the system says, well,
right, it doesn't change. I should point out for the folks who don't know, he and a friend were arrested in March of 2004, accused in the November 2001 murder of a Tribune sports editor, Kent Heathtolt. And anyway, that's what this case is. We've got a lot of notoriety back then. Kendall, as always, thank you, sir. We'll speak to you in a week.
Great talking to you. Bye.
You too. Kendall Coffey, ladies and gentlemen, spinning the law. When we come back, Derek Khanna, Yale Law visiting fellow and leader of a national campaign on cell phone unlocking. What is that? We'll talk about it. Steve Malzberg's show, Newsmax TV and radio.